Very good evening, students. Any volunteer, please confirm about the voice and the video, and I'll start the session. Any volunteer, please confirm about the voice and the video in the comments. Okay. Very good evening, Pragati. Kirti, very good evening. Thank you very much, Pragati and Kirti, for clarifying that. On that note, let's begin with this session. So, first of all, I welcome each one of you to my class on mock test of UP PCSJ. Let's begin with this class with my brief introduction. Those of you who don't know my name, it's Sandeep Khatri, and my areas of specialization, as you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have also shared the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel uh, through which you can connect with me and ask questions in relation to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. The same code you can use to get all the courses of Unacademy Plus, and you can get 10% discount as well. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So the moment you feel you're not clear with anything, feel free to ask your questions in the comments. So let's begin with the MCQs. Very good evening, Jiva, Amit, and everyone, those of you who have just joined. So it's a mixed question bank. You will get questions from IPC, evidence, CRPC, CPC, constitution. Okay, so a quick revision of all the subjects. Here comes the first question. Offense of defamation relates to harming association of persons, property of a person, family of a person, reputation of a person. Top 3 students to answer correctly. First one, Kirti, followed by Pragati and Kanika. And yes, everyone's answer is correct. That is D, reputation of a person. When it comes to the offense of the concept of defamation, first of all, that falls under law of torts as well and under IPC as well. When it comes to law of torts, the person, the victim, will get the damages under law of torts and the punishment for the offender under IPC. Now, when it comes to reputation, can you please recall any section number which says that uh, if reputation has been harmed, that will also fall under injury? Can you please recall any section number, important section number, that concludes this concept that once reputation has been harmed, that will fall under injury to the person? First one to answer correctly, Kanika and Pragati. Yes, section 44 I was talking about, where the term injury has been defined. So let's take an example. If the judge is pronouncing this, that this person, if the judge is reading the judgment and he's writing that this particular person has been convicted for the offense of rape. Now, whether that judge will get the punishment for rape, whether the judge will get the punishment for defamation. If yes, why? If no, why not? Yes, be quick. Why not, Kanika? Why the judge will not get the punishment? Completely correct. So when it comes to section 499, there are 10 exceptions, and out of one exception is this only. So the judge will not get the defamation. Next, section 511 does not apply to attempt of. Choose the correct answer. First one to answer correctly, Kanika, that is D, Pragati and Kirti. Everyone's answer is correct. That is D, which is basically culpable homicide. So why not? Because see, the first concept of attempt is that attempt is always punishable. Now, where it is punishable, if we do have any specific section, for example, attempt to murder, attempt to culpable, homicide, then the person will get the punishment there only in the specific section. But if there are no specific section, for example, like in the cases of theft, affray, or writing, then in that case, the person will get the punishment under section 511. Attempt to commit any offense is punishable with dash of the term of imprisonment provided for the offense. This is basically under section 511. Okay, I think the question is somehow incomplete. So basically, this is talking about section 511. Starting from Amit, Kirti, and Kanika, Pragati, everyone's answer is correct. Yes, that is A, half. Now, my counter question to each one of you who has answered A is that what if the punishment for the offense is imprisonment of life? What if the punishment for the offense is imprisonment for life? Then how will you apply section 511 in that particular situation? Yes, please. Okay. So Amit has mentioned the section and everyone has answered 20 years. Now, my final question on this concept. Your answer is correct. Now, you tell me, you will give punishment to that person 20 years or you will make half of it, that is 10 years. So, what is the final answer? 10 years or 20 years? Okay, Kanika is saying 20 years. Amit is saying half. Pragati 10. Kanika, when you will read section 57, okay, after this class you may read, then you will find that it is basically fraction of imprisonment for life, which means कि when what is going to be imprisonment for life, the time period for imprisonment for life, when you need to divide it for half. For example, for the purpose of section 511. So imprisonment for life will be treated as 20. And when you will make half of it, that will become 10 years. So here the punishment is going to be 10 years. Okay? I hope it's clear now. If yes, quickly give me a thumbs up. I'll move to the next one. And if still you have any doubts, you may ask. Clear, Kanika? Okay. On that note, move to the next question. Kirti, you have answered both, matlab like C and B both. So, what's your final answer? Okay, B. Only two students to answer correctly is Kanika and Kirti. Okay, so B is the correct answer, students. That is voluntarily causing hurt. Now, I have a simple question to ask. Students, section 319 of IPC is an offense or not? Please write down in the comments. Yes or no? Section 319 is an offense or not? And the same goes with 320 as well, by the way. The same answer goes with 320 as well. Okay, Kanika. Perfect. Kirti, correct answer. See, student, you need to understand that when it comes to section 319 and 320, 319 defines the term hurt, 320 defines the term grievous hurt. They are not offenses. So, what are the offenses then? In that case, 321 and 322, these are the basically the offenses. So, voluntarily causing hurt is an offense. And the term voluntarily, that is defined under section 39. Okay, so voluntarily causing grievous hurt, that is again an offense. So simple hurt is no offense. Okay, attempt to murder, no. So the correct answer is B, voluntarily causing hurt. Next, which of the following is continuing offense? Okay. Everyone has answered D, starting from Amit, Kanika, Kirti, and Jiva. Students, the answer is correct. Abduction is without any doubt a continuing offense. Now, I have one more question to you. Is there any difference between inchoate offense and continuing offense? Please, or they are synonyms. Is there any difference between these two questions? These two concepts? Continuing offense and inchoate offense, or they are the same, or there is a difference? Answer. Okay, everyone is writing different. Okay. Now, my next question in relation to this concept is why abduction is a continuing offense? Why? Why abduction is a continuing offense? Kirti, inchoate is not dakati. Matlab, dakati is not an example of inchoate offense. Because the place keeps changing. Okay. Kanika, when you will read the definition of abduction as well, when you will go through with the essentials of abduction as well, the last essential says from one place to another. So that one place to another, which one? So that is why it is a continuing offense. So your answer is correct, because the offense does not get complete. Okay, when it comes to kidnapping, both kinds of kidnapping, whether it is kidnapping from India, the moment you cross the border, the offense has been completed. When it comes to kidnapping from lawful guardianship, the moment the child is out of the lawful guardianship, okay, without their consent, the offense has taken place. But when it comes to abduction, it is a continuing offense. Now, last question, can you give me some example of inquiet offense? What are the examples of inquiet offense? You should write criminal conspiracy, not only conspiracy. Okay, it's criminal conspiracy. Kanika, you have mentioned question mark. So yes, abatement also a inquiet offense. Inquiet means incomplete. An attempt is also a correct example. So you can remember three of these examples, that is attempt, abatement, and criminal conspiracy. Which is not evidence in the following? Starting from Kanika, everyone's answer is correct. That is person's opinion. Opinion is never an evidence unless it is from some expert. That is expert opinion. An evidence sought through unfair means is top three students to answer correctly: Amit and Kanika. B is the correct answer, students. Uh, there are no section on this concept, so the answer is the most appropriate answer for this concept is that it is going to be admissible. Okay, just because the evidence has been taken from unfair means, that will not impact the admissibility of the evidence. The Indian Evidence Act does not extend to. You should not take more than 2 seconds to answer these questions. These are the most basic or easiest question you can think of. Direct question. Top three students to answer correctly, starting from Amit. Everyone has answered correctly. That is D, is the correct answer. Now, you please answer this one. Why? Why proceedings before arbitrator and Indian Evidence Act is not applicable. Why, if there is any departmental proceedings, why Indian Evidence Act is not applicable? Correct answer, Amit, because that is not judicial proceedings. Okay. Indian Evidence Act applies to correct answer, Kirti. They have a different separate procedure. These proceedings are not concluded by the judges. So basically, even Kirti and Kanika, just add one keyword in your answer, and that is judicial proceedings. They are not judicial proceedings. Everyone's answer is correct, starting from Kirti, Shalva, and Kanika, Amit, Smart Life. Everyone's answer is correct, that is C, both A and B. Court under section 3 does not include. These are your previous year questions from UP PCSJ. And this is the reason that I have included these kind of questions. Everyone's answer is correct, that is arbitrator. Starting from Kanika, Amit, Shalva, Kirti, and Smart Life. Correct answer. The Supreme Court held that in which of the following case the preamble is not the part of the Constitution of India? Top 3 students to answer correctly: Amit, Shalva, and Kirti. Yes, everyone's answer is correct. Kanika and Smart Life as well. And that is students' Berubari case. And then after that, in which one is the landmark judgment where the Honorable Supreme Court confirms that preamble is very much part of the Constitution of India? What was the name of that case? The landmark judgment. Keshavananda Bharati. Wonderful. The right to move freely throughout the territory of India comes under which article of Indian Constitution? So suppose if you are in Delhi, you want to visit Goa, you can easily go there. Okay? So you can move freely throughout the territory of India from place A to place B. So that fundamental right has been mentioned under article. Starting from Kanika, Kirti, Amit, Shalva, and Smart Life. Everyone's answer is correct. Yes, students, C is the correct answer. Article 19, freedom. Which part of the Constitution reflects the mind and ideals of the framers of the Constitution? Kirti, Kanika, and Amit, top 3 students to answer correctly, and everyone's answer is correct. That is A, preamble. You know, if you are not, I put it that way that if someone does not have the time to read the whole Constitution of India, right? And if that person goes through only with the preamble, that particular person will get a good amount of idea that what India is all about, that what are our beliefs, that what kind of India we are living in. One of the most repeated question in your exams, students, the system of dual citizenship within the country exists in. Dual citizenship, the concept of dual citizenship within the country. Kirti, Amit, Shalva, and Smart Life. Everyone's answer is correct, including Kanika. Yes, that is USA. Okay. Uh, I'm just giving you this one additional information that while we were deciding that we should go for dual citizenship or not, then we finally go with single citizenship. Okay, we all are Indians, whether we are from Tamil Nadu or Jammu Kashmir or Assam or Rajasthan or MP. We all come up with a single citizenship, that is India. One of the reasons why we have not opted for dual citizenship was that there may be chances that, because of that, that one spirit, that one country may be affected. Next one. The name of union given in the constitution is. Can you mention the article number where it is written? Starting from Kanika, everyone's answer is correct. That is C, India or Bharat. Okay. So that's the correct answer. Article 1. Basically, this question is from Article 1. Okay. Match the following. One of the favorite topic of examiners, the writs. Top 3 students to answer correctly: Kirti, Kanika, Shalva, and everyone's answer is correct. Amit and Smart Life as well. That is D. You should know the meaning of all the writs. A and B plan to murder C. The next day, they are guilty of. Okay, Kanika has answered B. Rest Amit, Kirti and Shalva D. What about you, Smart Life? B. Okay. Anyone wants to change their answer? Last moment. Chaliye. So the correct answer here is D. That is criminal conspiracy. Okay, now coming to how. How it's a case of criminal conspiracy. So what are the essentials? Kanika and whosoever answered B, Smart Life. Kanika and Smart Life. What are the essentials of Section 120A First one, two or more persons. So here A and B agree, plan. So there is an agreement. Two or more person who has agreed to commit an offense. So the third one, murder, is an offense, illegal act. Okay, it's an illegal act. So now whether the murder has taken the place or not, as per to the proviso, they have already committed the offense of criminal conspiracy. Okay. I hope it's clear. May I move to the next one? Okay. The offense of giving false evidence is also known as. Correct answer, Amit, completes as soon as you agree. Everyone's answer is correct. That is perjury. Starting from Amit, Kanika, Kirti, and Smart Life. Yes, B is the correct answer. The concept of inadequacy of consideration lies in. Kanika, A. Rest everyone is answering D. Okay, answer this one, students. In 2022, can there be a sale of immovable property in 1 rupee? Answer yes or no. In 2022, can there be a sale of immovable property? And immovable property, I'm referring to a house. Okay, a bungalow. Okay, a bungalow. Now, in 1 rupees, Amit, Smart Life, Kanika, everyone is answering yes, and that is correct. Okay, that is correct. And the concept is under section 25, explanation 2. So D is the correct answer. Okay, when it comes to section 25, clause 1, 2, and 3, they are basically the exceptions. What kind of exceptions? That there may be agreement, there may be a contract without consideration, and it will still be a valid contract if the situation falls under section 25 clause 1, 2, or 3. Okay, next. Kirti, yes, the court can always take a presumption. Okay, I'll complete your sentence on your behalf. I think you just want to say that the court will be cautious enough that the consent must be free. Whosoever is selling the property in 1 rupee, the court must be cautious. Okay? That the consent must be free. Because if there is no free consent, then again that situation will fall under voidable contract. Okay? If there is any kind of coercion or something like that. Chaliye. Next one. Consideration partly lawful and partly unlawful is void under section. Starting from Shalva, everyone has answered A. Kirti, Amit, Smart Life, and Kanika. Everyone's answer is correct. That is 24. Okay, I have a counter question for each one of you. That can we apply doctrine of severability? Can we apply doctrine of severability in section 24? Answer. I have got only one answer till now. That is from Amit, no. Shalva, yes. Kanika, no. Kirti, no. Shalva, can you please state reasons for your answer? Why? Why you have said yes? There must be some reasoning behind that. So, can you refer any section number for that? Or any case law? Or any logical point? In 29 years. 29 is different. 29 is uncertainty we are talking about. This is specifically for section 24 I am asking. No sir, I am not clear. Okay. Now let me answer students. You cannot apply doctrine of severability here. Okay. Now why not sir? Why not? Okay. जो lawful है उसे रख लेंगे, जो unlawful है उसे फेंक देंगे. So let me tell you students, this is not how contracts work. If there is any part of the consideration is unlawful, that will make the whole agreement void because of section 24. Okay. Next one. One of the most repeated question, threat to suicide amounts to. Okay. Starting from Amit, everyone has answered A, which is the correct one, by the way. Kanika, Kirti, Sharva, Smart Life, A. Even Kirti has stated the landmark judgment as well, Chikamma Amiraju case. But still, I have a question for you. Okay. And the question is, if there are two parties, A and B, and A wants to enter into a contract with B, but B doesn't want that. Now, if A is having a gun in his hand and he put that gun on his head, that I am going to shoot myself, okay, then this is basically a threat to suicide. Now, you tell me, if he shoot himself, how can, okay, I have already got the judgment. That is fine. But I want to know your logic. Have you read that judgment or not? That's why I am asking this question, that if A wants to kill himself, okay, if A is giving that threat that I will commit the suicide, how it is coercion to the another person? Yes, please. If you have gone through with judgment in detail, only then you will be able to answer these kind of questions which I am talking about. I hope the question is clear to everyone, right? If the question is not clear, please do write. I'll repeat myself. There's a pin drop silence in the class. Okay, I hope everyone is thinking about the answer because it's not that easy. Okay, I've got the answer from Kirti. Not write judgment, but maybe avoid charge of abatement of suicide. No, 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 Kirti. See, right now we are discussing questions of Indian Contract Act, which means we are dealing in civil law, right? That so it has nothing to do with IPC because other person may be his close one. That's the assumption you are making, Amit. That's the assumption you are making, not the correct answer. Should I answer? Because it's a crime in IPC. Again, Kanika, and like same reasoning for you as well, Kanika. We're dealing with see IPC has nothing to do with this particular situation. Matlab, obviously, if he attempt to suicide, then you may get that person punished under section 309. But right now we are discussing why. Okay. Uh, Now everyone, please listen carefully. I'm giving you the complete reasoning. Okay. First, I'm repeating the question, and after that, I'm telling you the answer. Okay. Now listen carefully. My question was, why threat to suicide amounts to coercion? You know the answer is coercion. See, as far as PT is concerned, if you are going to take coercion, you are going to get full marks. But what about if the same question comes in front of you at the time of mains examination or at the time of interview? Then you have to give reasoning, right? That's why I have asked this question. Now answer to this question, why it amounts to coercion. See, when it comes to section number 13 that defined the term consent, and section 14 defined the term free consent. Now, back to my example, if A wants to enter into a contract with B and B doesn't want that, so basically there is no consent from B's end, there is no consent. And if A is saying that I'm going to shoot myself unless you are giving me the consent for the contract. And if because of that particular incidence, because of threat only, if B is giving the consent, then that consent will not be free consent. I hope everyone will agree on that. He said that's not free consent. So the answer is yes, that's not free with free consent. Now, why that is not free consent? Is that a case of misrepresentation? No, absolutely not. Mistake? No. Fraud? No. Whether that's a case of undue influence? No, that's altogether a different concept. Then why coercion? The answer is yes, it's coercion. But why coercion? Because if that person, there is a mental pressure on that person that if I am not giving the consent, this person will die because of me. And now just think about this. Even if there is no relationship between that two, that is not important that they are related or not. How will you like that someone died because of you? That's a mental pressure on you, right? So that's why that mental pressure is because of that's not undue influence, that coercion on you, that you left with no other choice but to say yes to that person. I hope it's clear now. That if it's clear, quickly give me a thumbs up. I'll move to the next one. Amit, if you are saying if you are saying that in that case that particular coercion is not working on you, there is not going to be any liability on your head as far as civil or criminal. Okay. Yes, Kirti, you may state IPC, But the thing is, why threat to suicide amounts to coercion? That has nothing to do with IPC. Okay. Chaliye. Next one. No, that would not be abatement. You are not the one who provoked that or intentionally aid. Abatement is because of provoking, because of conspiracy, or because of intentional aiding. In your case, Amit, you have not done anything like that. So there, don't worry, I'm telling you, okay? There will not be any liability on your head, okay? There is a famous case law on this as well of IPC in abatement. There is a famous case law. In that particular case law, the facts were that the wife actually put kerosene on her, and she told her husband that I'm about to, burn myself. And the husband gave her the matchstick. Now you tell me whether that's the abatement or not. Answer in the comments. That's the abatement or not if the husband is giving her the matchstick. Please go on. Yes, it is. No, Amit, the moment husband gave her the matchstick, that's intentional aiding. You are helping her out. Okay? And she had already put kerosene on her. So there is no way she is kidding, right? Next. Which of the following is incorrect? I don't think you should take much time to answer these questions. Easy one. Okay, starting from Shalva, everyone's answer is correct. That is B. Kirti and Amit. Okay, everyone's answer is correct. Self explanatory, nothing much to explain. Okay. This question is from CRPC students. Point out the incorrect response. The period of limitation for taking cognizance of an offense shall be. Okay. Okay. Starting from Kirti, everyone's answer is D. And yes, students, that is the correct answer. So, yes, 5 years if the offense is punishable with imprisonment exceeding 3 years. Okay, chalo, let's ask this. I hope everyone is aware with this recent case, uh, Aftab Poonawala case I'm talking about. So I'm just giving you an application based question in relation to this concept, and that is if suppose after 50 years, mark my words, after 50 years, if the case got, matlab, like if the police got to know that there is some girl named so and that her dead body has been found after 50 years. So even after 50 years, uh, the police, the person will get the punishment or period of limitation will be applied there. चलिए जी. No limitation, Kirti. Completely correct answer, students. When it comes to either it is a complete case of murder or culpable homicide, which we will get to know later. But as of now, okay, it is going to be culpable homicide or murder. Most probably murder only. So when it comes to punishment of any offense whose punishment is more than 3 years, there is no limitation period for that, because of obvious reasons that it's a crime, it's an offense, it's a grave offense. The concept of plea bargaining has been taken from which country? Kirti, Shalva, and Kanika, top three students to answer correctly, and that is USA. Correct statement, Kirti. Charge bargaining is in USA. In India, we have sentence bargaining. Starting from Kanika, everyone has answered C, 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 C. And that's the incorrect answer. Incorrect answer. Incorrect answer. What is section 156? Yes. What is section 156? Under section 156, have you read any term like CBI or CID? Have you read any term like CBI or CID? So, CBI and CID are completely two different organizations. ठीक है जी, इनको सीबीआई कोर्ट से ही जो है वो गाइडलाइंस आती हैं. ठीक है, so that magistrate has nothing to do. So the answer is neither A nor B is going to be the correct answer. Okay, it's a good question. ठीक है, I hope it's clear. Yes, Shalwa, that is directing police. Okay, let me give you the current affairs reference of this question as well. Recently, there is a plea that has been submitted to the High Court, Delhi High Court only, that the case should be transferred to CBI. But that was rejected. The reason was that prima facie only you cannot say, not prima facie, like you just cannot presume that the Delhi police is not efficient enough. Right? I hope you have gone through with that order as well. It's a recent only, right? So that High Court has also rejected that. But the reason was very simple, because the police were doing their duty, right? Next. This is the question from CPC students. The word resides used in section 19 of CPC means. ये आंसर चेंज हो रहे हैं। एक्चुअली ना, चलो मैं बता ही देता हूँ। जैसे अब तो खैर मुझे पता लग गया है, बट जब मैंने स्टार्टिंग में यूट्यूब क्लासेस, मतलब इस तरीके से क्लासेस, यूट्यूब क्लासेस स्टार्ट की थी, तो यूजुअली क्या होता था, स्टूडेंट्स आंसर करते थे, मैंने आंसर पढ़ लिया, और थोड़ी देर बाद मैं देखता था स्टूडेंट ने अपना कमेंट डिलीट कर दिया और आंसर चेंज कर दिया। एंड यूजुअली आई मुझे ऐसा लगता था कि मेरे माइंड में कोई प्रॉब्लम चल रही है, मैंने अभी तो उसका आंसर ये पढ़ा, तो अब तो ये वापस शो कर रहा है। वो मुझे बहुत क्लासेस के बाद ये पता लगा। आई वॉज डाउटिंग माई एबिलिटीज टिल देन, कि नहीं मैंने तो ये पढ़ा, मैं ठीक से नहीं पढ़ पा रहा हूँ या मेरा दिमाग घूम रहा है। ठीक है, क्योंकि वो ABCD तो वैसे ही होते हैं, तो वैसे ही थोड़ा बहुत लगता है कि कुछ ब्लैकआउट हो गया होगा, बट नाउ आई एम लाइक कंप्लीटली फाइन कि हाँ ये स्टूडेंट्स ही कर रहे हैं। ठीक है, चलिए। तो ये अभी भी कुछ आंसर्स डिलीट करके आपने किया, तो मुझे वही कॉल बैक आ गया। ठीक है, चलो। Yes, A is the correct answer, students. That applies on only natural persons, right? That will apply. See, resides, company never resides. Company के केस में, और when it comes to artificial person के केस में, there is only two probabilities. The one is the head office only, or the one office only, or the branches. That's it. There is no residence when it comes to artificial person. So the correct answer is A. Which of the following deals with the procedure when party fails to present written statement called for by court in CPC? I think even this question, the options are so easy that if you at least know the order of written statement, you can easily answer that. Shalva, Ladley, Kirti, everyone's answer is correct. That is B, order 8, rule 10. Who said that? In jurisprudence, do expect these kind of the questions only, that what statement has been passed by which jurist. So who said that jurisprudence is the philosophy of positive law? I can see jurisprudence part is weak. Kanika, correct answer. Kirti, correct answer. That statement is passed by Austin. A is the correct answer. Who wrote the book The Concept of Law? किसने लिखी है जी? Who wrote the book The Concept of Law? Everyone's answer is correct. That is D. No, Kanika, please do correct yourself. The correct answer is HLA Hart. Okay. D is the correct answer. Last question. Which one of the following is a legal person? Which one of the following is a legal person? Legal person, legal person, legal person. Everyone's answer is correct, starting from Kirti, Ladli, and Shalva. Yes, it's B, that is Sardar Daman Nagpal Corporation. So these were the questions. Now, if you have any doubt, you may ask. So this is the link of my profile, my Telegram channel, and this is my code Khatri10. So students, here is an important information that a price drop alert for judicial aspirants. The offer to start from November 25th. So for Plus and for Iconic, for both there is a price drop for 24 months duration and 12 months duration. Yes, anything else? If it's all clear, quickly give me a thumbs up. I'll wrap up the session. You all are welcome. Shalva, Kanika. It's okay, Ladly. Okay. So this is the judiciary test series for December, students. This is the batch which is going to be recently started from from November 28th, Sarthi 4.0. This is the batch which has been recently started, Rajasthan State Judiciary batch. There is one, this is the result from Unacademy of Rajasthan Judicial Services Examination. These are all the features of Unacademy Iconic. This is the YouTube and the Telegram channel of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.